Good day, listeners. This is James Lech from jameslech.co.za. I am a academic researcher and I specialize in non-native electromagnetic fields in South Africa and studying on different mitigation options, what your legislation options or solutions are, what are the aspects of helping your health for you, yourself, your family, and your loved ones. And today we are very fortunate to have a very, very successful and skilled attorney from Maritz Smith Inc. Attorneys. His name is Michael, and his areas of practice focus are telecommunication law, mergers, disposals, insolvency law, arbitration, property transfer law, a whole bunch of different areas. And apart from managing a medium-sized law firm for 15 years, Michael has extensive dispute resolution exposure in South African lower and higher courts, including reported cases. He has personally assisted in a great number of intermediate and large merger acquisitions, telecommunication industry disputes between large network operators, takeover strategies, private equity acquisition and disposals, as well as forensic investigations in commercial matters, and has appeared personally in the Competition Commission, High Courts, and Lower Courts of South Africa. So he has really, been around. He's greatly applied himself. I got to actually personally meet him last year, where he was at his residential estate. They have named South Downs, and they had Atlas Towers as wanting to erect some telecommunication towers. And he was very instrumental at helping mediate the discussions and find the best way forward for both the residents of the estate, as well as for the operators. And he's going to share with us some of his views on my research, on what he's seen on other research, and his experience with the law, and what his recommendations are for persons that are concerned or wanting to find the best mediation way forward. So, Michael, thank you very much for joining us this evening.
Thank you very much, James, and thanks for your kind words and introduction. And hi there to all the audience members.
So why don't we start off? Why don't you tell us a bit about, why do you have an interest in non-native electromagnetic fields, and your personal view or your interest with respect to the law?
Well, it has a fairly lengthy history. When I was an intern attorney in 1999, I was exposed to the Sony Ericsson T9 mobile cell phone, which was all the rage at that stage. And we were, as part of our intern duties, required to spend fairly lengthy times communicating with the principals, clients, and public officials. And what happened to me in one instance, when I was on the cell phone for quite a long time, is that I experienced sharp, painful headaches when I was using the cell phone. And it automatically led me to believe that, something was amiss. I couldn't quite pinpoint exactly what it was, but I wrote it off to perhaps a biological sensitivity to whatever the signals were that were radiated. And that sort of piqued my interest over the years in getting to know a little bit more about the field of electromagnetic frequency radiation, non-native EMF, as I refer to it, and specifically as far as it relates to the devices that we've come to so closely be associated with on a daily basis, our mobile telephones and basically all other kinds of devices that are electronically enabled and which emit electronic frequencies, and how it affects us and our functioning. Being a jurist, I've also been exposed to a number of matters which involve the telecommunication laws. That's one of my areas of specialization. And I've extensively researched quite a number of issues, and I found it quite interesting that it happens that the technological advances far outpace those of our public health laws and our laws in general. So that was something that was quite a large concern area for me, but also obviously very interesting. And and having researched it, and having to dwell internationally for the research, it made me conclude that there's obviously a lot of work to be done within the South African context.
No, great. It's definitely, it always helps to have these personal experiences, because that's sort of, intuitively, as you said, with your phone, you picked up a reaction, and, it drove your curiosity of something as, a array here, and wanting to find what's going to be best for you, and your dad yourself, and a husband, so you do want to look out for what's best for you and your children. So, I mean, you were kind enough to also review my research, my thesis. You said quite a lengthy printout. I don't know how much of it you got to go through in detail, but I know you are quite an astute researcher yourself, and you've also been keeping up to date with international research, recently with the whole Ramazzini paper and the NTP study, which provides supportive evidence of, the RF non-native EMF to be upgraded to a type 1 carcinogen. But what are your views, of the research of mine, of how it applies to Africa, and what are the also differences or your supportive mechanisms from international research?
Well, I think to start off with your research, and I think I said this when we initially met last year. I think it was a year, or perhaps a bit longer than a year ago, is that your research is addressing a very large lacuna, or a void in our legal system, where technology has so quickly outpaced the public health sector and the legal sector that our laws typically all over the globe are slow to adapt. And I think especially in this field, there's a huge void in the South African legal context. And what your thesis is doing is it's basically addressing that issue for the very first time on a very high level, bringing into play both biophysics, bringing into play the area of law, bringing into play public interest, because we've seen a huge proliferation of, for instance, cell phone towers all over some of the major CBD areas throughout South Africa, and we've had mixed reactions to it throughout the members of the different societies which it affects. Some legislation exists to regulate the erection of certain of the structures to which some of the non-native EMF devices can be applied, but technically speaking, there's nothing really in our law that protects us as individuals from these devices going up all across the country. Nothing that really says to us whether or not it's safe for us as human beings, whether it has any biological effects on us, and whether there are any kind of regulations in place to measure it, to keep us safe. And the reason why I think it came to the fore recently is, we've seen such a proliferation of these towers and devices going up all across the country so suddenly. And that's on the one hand, where the need to communicate and the need to be connected forms a new integral part of our social fiber. But it's always subject to the constitutional imperative that we have the right to a safe environment, an environment that's not harmful to us or to our children. And that's embodied in Section 24 of our Constitution. Section 24A basically says that everybody has the right to an environment that's not harmful to your health or to your well-being. And then Section 24B goes a little bit further, and it says that we've got the right to have the environment protected for the benefit of present and future generations through reasonable legislative and other measures that that prevents pollution, ecological degradation, promotes conservation, things like that. And we, what we immediately realized is that the constitutional imperative to the right of a safe and healthy environment sometimes needs to be explained and regulated a little bit better, because I think when our draftsmen of our constitution back in 1993 first set about this task, I can't think that they would have imagined that there would have been such a major breakthrough in technology, and that the technology would be deployed in our society so pervasively as it is being done at the moment. And also that, you know, the effects of certain of the non-native radiations would have the kind of adverse biological implications that have now recently been internationally published, to the shock and horror of quite a few people. I've always kept my eyes on the studies that have come out from international study groups concerning safety of electromagnetic frequency radiation, specifically when it relates to handheld devices, our cell phones that we keep all around our bodies in close proximity. And the research up to now recently has been fairly inconclusive on health hazards. So, you know, with the most recently published studies, it clearly indicates that the public in general have an apprehension on whether or not it's safe for us and for our children, and that apprehension now seems to be reasonably well founded and scientifically researched to be adverse to our health. And I think for that reason alone, it's a cause of concern, and it needs to be addressed rapidly by empirical data, you know, I think quality research and urgent legislative measures to address the matter, because obviously at the moment the public's at risk. It is a public interest issue, and I think that debate has to start getting traction in all earnest right now.
Yeah, no, you're completely correct. And I found, a lot of it also comes down to the issue of echo chambering, and like in the Constitution, we mentioned that it's a right to a safe environment. And the words it's a very vacuous concept. What is considered good or what is considered bad? I mean, you only know what's good when you can understand what is bad, and vice versa. You can only understand or state what is bad when you can narrate and describe what is good. And that was a big challenge in my research of looking at legislation, trying to establish a metric. And in terms of even the echo chambering industry markets, the ICNIP guidelines, where safe is as long as you follow the thermal regulation, there's no adverse effect. But when we apply the biophysics, and the research it's been well documented for decades now, with proving that there's this effect. And then we're able to transfer that and segue it onto the medical cost. We find out that the health implications are far more costly to the state as a result of the radiation. I mean, even it's showing now that's one of the leading contributing causes for obesity and diabetes. And in South Africa recently, diabetes was upgraded to the second leading cause of death in South Africa. And these have, large implications and changes. And in terms of this echo chambering, you can always pay on Google Ads to see what your rankings are, all that adjustments go. Because even myself, I've had a number of different court applications, and in my personal capacity, I was judicially ruled that non-native investors do have a capacity to cause, to have a biological capacity to affect it. But only the issue is that when you have these type of court cases, that they aren't publicized afterwards or referenced more, and becomes also a marketing game, and it's tricky. And I said with the recent NTP and Ramazzini studies, we've had lots of groundbreaking studies in the past that can show the influence and effect very easily and very conclusively. But with the traction of the more money or more media going on, with it, it was much more publicized. But even at the press conference, particularly after the Ramazzini study, where they had the directors of the NTP and Ramazzini study talking about their results and their experiences, and they disclaimed in the end that, based on the results, by all means, keep your cell phone away from, when you're pregnant, keep it away from pregnant mothers because of the extra volume of exposure to the child. Keep it away from children and keep it away from these organs. But they disclose that they are not policymakers, that they only do the research, they provide advisement, but the power resides in the public and in the legislative institutions of taking applications to court to mandate these national legislations of protection. And you mentioned the Constitution, but I thought maybe you could also dive more into, from your experiences, how you've engaged in areas, or which specific piece of legislation, be it agricultural or telecommunication or the promotion of Equality and Prevention of Unfair Discrimination Act, which different acts or elements would be useful in person taking these administrative steps if they feel their rights are being violated?
Well, I think that's a very important question. Because the technology has so quickly outpaced our legislation, we have very little to go on. And basically, we're stuck with what we have, which isn't the perfect solution. And I refer to it sometimes as collateral legislation. The main legislative issues, we've got to separate what we can turn to protect us and have recourse into. One part of it is our legislative framework, which is our laws that are published through enactment by the legislature and parliamentary processes. And then secondly, you've got your positive law, which is decided court cases over the years, and that's one of the aspects in our legal system that ensures the consistency of the application of our legal principles over the years. Our law is not something that's static; it also develops, thankfully. And if you look behind me, for example, the books range from 1847 to 2018, and generally speaking, there are 4 volumes each year that get published, and these are our decided cases, which our jurists, as in general, refer to when we do our legal research. We have a look at our legislative framework. We obviously also look at things that aren't caught up in paper, which is basically our common law system, which we inherited from many hundreds of years ago from the Roman Dutch legal system. So we have I would almost call it a bouquet of avenues which we can follow as lawyers and as affected people when you're faced with a situation like this. So first off, my advice to the members of the general public would be to be vigilant. Normally these structures that enable the non-native electromagnetic frequency devices are erected through a public participation process in terms of our laws, our National Environmental Management Act, which says that if these structures are going to be erected and has certain dimensions and certain proportions, or it intends to be higher than 10 meters, which invariably they do, or 30 meters, sometimes they go up to 36 or even higher meters, then it has to form part of a public participation process. Certain affected individuals have to be given the right to be heard, because some of the rights that affect them are, for example, your right to privacy. Imagine being on holiday for a week in Mauritius and coming back, and all of a sudden you have a gargantuan 36-meter cell phone tower looming over your property, and that would infringe your right to privacy on the one hand, when cell phone technicians, for example, would arrive to service the cell phone tower. They had to, maybe apply technology to the top of the tower. So there would be an invasion of privacy on the one hand. On the second hand, you'd also have a pecuniary loss, a financial loss of the value of your property, because living right next to a massive cell phone tower is not the ideal selling point of anybody's house. Even though we have to balance that with the growing demand for data and prevalent data consumerism. And what I've noticed, and this is a personal observation, I don't proclaim that it's something that's substantiated by empirical studies, but there was a remarkable correlation between the sudden explosion of and proliferation of cell phone towers and the race to get fiber optic cable networks enabled throughout, for example, the Gauteng area in South Africa. So I believe that it's a race for the biggest slice of the data cake, if you could call it that, between your telecommunications operators. And the one believes that his technological solution to feed that demand is as good as the other. And I believe there might be merit in an argument like that. But when we stand back for a moment and we consider the import of the international recently published studies, it demonstrates that the reasonable apprehension that members of the public have, certain members of the public have, about the adverse health effects of these devices have merit. So the towers in itself aren't the issue. It's the equipment really that they apply to these towers that's the great issue. So when members of the public are confronted with these little seemingly Latin-looking notices that are often displayed, as it should be in terms of legislation, they should make it their business to go and investigate. Take a moment, stop your vehicle, get out of your car, and have a look at what exactly that notice says. Because typically when such a notice goes up, it invites the public to participate in something that might affect them. And if you're not a lawyer and you don't know a lawyer, you can always take the wording of that notice and you can take a picture of it with your mobile phone and you can tap it into Google when you have a bit of time, and that will kind of translate it for you and you get a better idea of exactly what it is that this notice is trying to communicate to you. It's not immediately apparent from the wording. Sometimes they use the wording of the specific legislation, which they are required to do, and that makes it difficult to comprehend for many people. And in turn, that has the knock-on effect of, dissuading people of digging into maybe researching it a little bit better than what they should. So my advice to the members of the public would be, if you do see this, or even activities that resemble the construction works of towers, you'd easily see it by the footprint that they're erecting, and then obviously the very first thing that you'll notice is the identifiable bottom mast part that goes up first. That's a clear giveaway. Usually by that time, it's almost too late to stop the process, because once these towers are erected, it is far more difficult to have them taken down in our courts of justice than what it is to stop them. So the key word really for members of the public is vigilance. Be observant of your surroundings. Be aware of the fact that there is a large and a very, very aggressive drive for the biggest slice of the data cake, and cell phone tower companies enable cell phone companies to mobile operators, for example, to mount equipment to divert and run that traffic, that data traffic and voice traffic. So that's really the major part. They have to be the eyes and the ears, on the ground, because by the time the tower is up, it's almost too late to go to your attorney's office or to try and lodge some kind of a complaint or an appeal or a request to have it stopped for certain reasons. So basic message is be vigilant, be on the lookout, and if anything happens, you've got to react very, very quickly to make sure that you protect your rights as well as the rights of the environment, especially in ecologically sensitive areas. We recently had an instance where it was proposed that a 36 meter electromagnetic frequency enabling tower would have been erected in a very ecologically sensitive area near a red data species of bat. So you can imagine for yourself, bats navigate at night using echolocation. And if you have high doses of electromagnetic frequencies interfering with their echolocation in an already endangered species, it would certainly not be conducive for their continued existence. So not only are you considering, your own health and safety and that of your children and the members of the community and public at large, but, you also have to give a bit of thought when you're dealing with these towers going up all over the nature areas.
Yeah, I completely agree with you, and I appreciate the explanation there. It is difficult because, I found in my research, and still today, most people are very over scared or emotional regarding cell phone towers because they have such a dramatic visual discrepancy to them. You have clear skies, and all of a sudden it's up, and you have this unknown awareness. And the public is not always aware that non-native EMF includes high voltage AC, so your transformers, your power lines, and also blue light. And all of these have different biophysics changes to metabolism and nonlinear effects to the human body and as well as to nature. And what we're finding, especially in Cape Town, it's a lot of the case or complaints comes to even when there is the public participation, the members would oppose, majority of them, they would give valid just reasons, but their application will be steamrolled. So apart from illegal towers going up, they would try the public participation route. And like you said, the tower goes up, and once it's up there, it's this very costly and difficult process of how to go to court. And even though what to argue or not to argue, and not everyone is able to go to or apply, make the applications themselves like I did, because it is sort of a testing process where the courts or in the law it enables private individuals to approach them. But from a practice point of view, you get highly deterred because there's like sort of a testing process, and creatures of habit, the courts do prefer an administrative process to be followed. So what's happened is that not with you, but some of your learned colleagues in the field, they would take members of the public complaining, and they would take them for a very long economic ride, where they're saying, we need to spend X amount of fortune and paying them to do research, and they're going this whole other complicated route versus what the reality is, and to sort of help them avoid, because we want them to encourage engaging with attorneys and thereby, if need be, an advocate. What are sort of the processes they should do in selecting the right attorney? What questions to ask, and what sort of the red flags are if they're going to be taken for a ride? Because, how to avoid this personal cost and stress to themselves and or for community to come together to employ the services of an attorney like yourself with the skill sets on navigating this situation on their behalf and or having going to court, and making sure what are the sort of specific orders or recommended orders that the judge should make in the application with the notice of motion.
Well, I'm very tempted to tell the members of the public to visit www.expertlaw.co.za if they need somebody to help them with that. But I might not be always the right person to go to because I'm geographically constrained to mostly Gauteng. But that shouldn't limit any members of the public to seek out, mobilize firstly. I think that the first place to start off with is get together, mobilize as concerned members of the public. It certainly doesn't affect only one or two individuals. in any community, you will notice immediately that there are more voices than just yours that have cause of concern, especially now that it's scientifically, backed up, that these apprehensions that members of the public have are reasonable. So the first thing is to form a collective, a pressure group, a society of concerned residents, affected individuals, at least if they're not concerned, because you could be unconcerned by the fact that you're going to have a cell phone tower. It promotes your communication. You might be in a flat spot where you can't get cell phone signal. It's the best thing to happen ever. But everybody has the NIMBY principle, which is not in my backyard. Please, get us the cell phone tower, but please don't build it right next to my house, because we'd rather build it somewhere else. So, you don't really, if you don't participate in that process as an individual or preferably as a collective, you're not going to have a voice. You're going to have a say as to where the cell phone tower might be erected, or the tower might be erected that enables any other manner of radiation. So forming the collective is your first step. Establishing exactly how many people are affected by it, and how many people have the apprehension that it's going to adversely affect them. And then in that collective, you identify the right legal person in your area. Now, for that to happen, a Google search is very typically your first port of call. But you've got to engage an attorney, firstly, who has knowledge of telecommunication law. And these laws include your environmental laws, what we have at the moment, which I referred to initially, and also your decided court cases, which make reference to certain instances of similar disputes that have been decided by our courts previously. So you don't have to reinvent the wheel from the get-go. So your first port of call would be to identify the right jockey for the horse, as they would call it. And that means doing a little bit of research, taking some time, asking around, doing research on the internet on different kinds of attorneys that promote their services, that include telecommunication services, that include environmental and public health right protections. So it's a fairly straightforward research methodology initially, to maybe round it up to a panel of 3 at the most attorneys who are the prime candidates for assisting the members of the public, and then a simple inquiry either by telephone. Usually, most of the attorneys are prepared to do a first consultation free of charge, and that's just to get to the rub of the matter, to get a better understanding of whether this is a kind of matter which they are equipped to take upon themselves, whether they have the necessary expertise and qualifications to take on the brief. If they're not, then they'll either refer the member of the public or the group to a colleague who's maybe better equipped for it. Or what the members of the public can do is they can contact their local law society, who can direct them to a practitioner, a legal practitioner, who specializes in specifically, telecommunications law, public health law, and that would better serve their interests. If they don't know where to start, if they don't know who to ask, I invite them to contact us on our website at expertlaw.co.za to just get guidance if that's all they need, just to put them on the right track as to a practitioner in their area who can assist them. Because this is definitely a developing area in our law. Not everybody specializes in it, and I think that many practitioners are caught off guard if they haven't been immersed in situations pretty much as I have been. Almost being put on the spot to make it your business, to understand exactly how this is going to affect you and what to do about it. So it basically forced me to do the research, to do it thoroughly, and to do it not only in the interest of my own safety and that of my family, but we also had approximately 128 other families who were equally concerned. So I think that and they formed a collective. And if I could take a precedent off that, I think that would be my best advice to each member of the public out there. Be vigilant, see, have a look and see, your surroundings. You'll notice immediately if something is looking like it's going to have a large footprint or a very tall tower attached to it. And then you start doing your research in your immediate vicinity and be knowledgeable. Get your collective going, and identify those people who might know an attorney in your area, or who might have somebody that they know who is a practicing lawyer, who can at least just give some kind of guidance. Because this is not the kind of thing that an ordinary member of public should take upon itself. It's very difficult as an ordinary member of public to try and comprehend exactly the implications of the processes that are being embarked upon when you see these public participation notices passed all over town. It's difficult to, if you're not a practitioner with a fair amount of experience, it's difficult to anticipate exactly where the thing is going and how it's going to affect you. So definitely be vigilant, definitely mobilize, and definitely get your feelers out for a practitioner in this area specifically that knows exactly what to do, how to stop the procedure. And if we look at grounds of stopping the procedure, you look at our basic administrative rights that each person in our country has. It's also enshrined in the Constitution. So all of us have the right to fair and just, equitable administrative action, which means you have the right to be heard. You have the right to information before something that affects you as an individual is enacted or is affected in your area. And typically what we've seen in the recent past is that many of the notices that have gone up and some of the attempted structures were foiled basically by their own incompetence. Lack of a proper understanding of the law by some of the consultants that were hired by these companies, which renders these procedures that they attempt to be susceptible to objection, which renders them fatally defective, which renders them procedurally irregular, which renders them susceptible to strenuous objection to many unconsidered consequences of the intended actions that they try to take. And when I say that, I mean we, for example, had a recent example where a green leafy suburb community was faced with the prospect of an old and almost redundant church, which was going to be converted into a massive tower site. And the characteristic of the community, the characteristics of the community over few generations have been, one of peace and tranquility, quietness, and neighbors having the general enjoyment of the views that they're entitled to of their properties over many, many years. And in fact, they've become so accustomed to and inured to these views that they place a premium on these views, over and above that of a large tower looming over your property. They would prefer the trees they've always had. So, that community was particularly upset by a prospect such as that. Fortunately, the procedure that was adopted by that particular instance was fatally flawed from the outset, and we were able to stop it immediately. And the community were extremely relieved. And through that process, what happened was that it led to a chain reaction by them becoming more vigilant. They started looking out for these notices, and they started talking to their friends about it, and their friends had stories that they could share about it, how they were affected, how through not really knowing exactly how to handle this, many people's rights were adversely affected, when the real remedy almost lies in itself sometimes when procedurally or substantively these operators act inappropriately, take some shortcuts. They do get caught out if somebody knows exactly what they should have been doing and find out that they haven't been doing what they should have been doing. But the kind of relief that you want when these things threaten to go up is injunctive relief, which basically is in layman's terms, it's an interdict. It's to stop you from erecting these towers, either firstly because you haven't been given the fair right to be heard as a member of the public, or it affects some other kind of right, like the right to privacy or the economic value of your property. It's going to adversely affect the skyline of your suburb. It's going to have an adverse effect on your privacy. These towers, they need to be maintained. It's a very important part of the social almost contract, if you could call it that these towers need to be maintained. So there is going to be a sporadic invasion of your privacy. If lightning strikes these towers, for example, you live right next to it and it falls over, there's a contingency that it could collapse, and measures have to be put in place for these eventualities as well. So the right kind of injunctive relief would be to say, all right, let's stop everything until you could tick all the administrative and the procedurally substantive boxes to tell me that I've engaged with all of the members of the community who are affected by what I intend to do here, and that they've had the right to voice their concerns, and that their concerns have not just been voiced, but have been legitimately considered. Because that's the other part of it. It's not just giving the individuals who are affected by it the right to be heard. You have to genuinely consider exactly how it's going to affect these people. Because if you just listen to somebody who tells you that they believe that they won't be able to resell their house in 5 years' time from now because of this massive construct that comes up right next to their property, without regarding their rights and putting in place mitigating factors, then you're not substantially complying with your duties as the guy who erects the tower. Now, not everyone knows about this. Our courts know about this very well. Certain jurists know about this very well, and most definitely the consultants and the companies who are tasked to erect these towers know about it very well. They have the advantage over a normal member of public.
So it sounds that like administrative law or administration is the best tool or arsenal for handling the situation. And like I said, it's the best Achilles heel with applications and avoiding public participation being steamrolled. Because in the Telecommunications Act, licensed operators are required to give the technical specifications per site of the erection. So the transmitter, the angle, all these details. And in my research, I found the CEO of ICASA wrote that they have some of the GPS coordinates, but they don't have the technical specifications per site, and that the telecoms refuse to give them that information. And if they had requested or furnished them all, that they would then lose business from it. And even in our own municipality, the policy states that they must also be furnished with this information, and the permit requires it, but it's not furnished. And the city says they've requested multiple times, and they say the installers refuse to give it, the technical information. And what happens then is that you have, the other issue is that the officials themselves say they're not skilled or trained to evaluate of what the permit design given of the engineering structure of the structure is, and what it looks like afterwards. So in many cases, they might say they're going to install an omnidirectional. It seems, not very hazardous, but then they install a number of directional transmitters instead. And the game comes back to this vacuous argument of what is safe or not safe. And by not having these technical specifications, one is not, public or technical scientist is not able to determine if the installation configuration is going to be really safe or not. I even had some of the city officials themselves saying how when they went to a site when they were observing an erection and they saw the design plans of how the transmitter was meant to be installed, but the installer on the whim changed the angle of the transmitter and had it actually pointing towards a roof of a house because on site he felt, well, this gave a better propagation of the signal. But it was different to the original instructions he received from his design team. But again, if he wanted to keep those, the city official wanted to keep those plans, he was denied it. So this makes it quite difficult because we can't exactly say what's safe or not, and wireless propagation is very challenging because it's the issue of maybe in direct line of sight where we see transmitter, the levels might be very low, but we have this thing called reflection and localized hotspots, which means that the home on the side or a school or nursery area ends up actually having a much higher elevated radiation level than what would normally be identified or seen. So,
yes.
I always recommend when I'm giving talks on that is to request the 3D and 2D propagation model. And this actually, all telecom companies do generate it themselves, and it shouldn't cost you anything as the public consumer, but it is the right to know information of knowing, what are the radiation levels, how does it interfere with other potential service providers. And it's very key, I've always advised to ask for the field intensity or volts per meter table or legend and not the ICNIP percentage, because it's also very misleading information. As you said, only the installers themselves understand the information, but a public health official won't understand it. Yes. So when you said, getting these groups together and having these participations, typically at a public participation, they would call the installer service provider to bring their public scientist or to talk about it and say, on full trust and whim, this is perfectly safe and there's nothing to worry about. However, what was your experience of, because with your estate, you called me in as a scientist, where I'm meant to be the independent party, not funded by industry, and to give my evaluation based on the science and personal experience on the science. Do you feel that has an impact on swaying or better educating the community, or does it not really have much of an effect during the public participation process? Or is the municipality themselves required to actually pay or invite or hire an opposing party to give the other side of the science?
All right, so we have two questions there. So the first one is, without a doubt, involving somebody such as yourself, who's an independent expert in these areas with the extensive research that you've done already, was key. Because members of the public have a reasonable apprehension, but that's not enough to substantiate thorough grounds or reasonable grounds for an objection. They have to be backed empirically, and they have to be backed by some measure of rational study methodology, which is why we reached out to you, because, knowing that I know a bit about the law and its application and interpretation, I knew what my limitations were as well. And that's why we immediately realized that somebody with your kind of expertise is absolutely necessary. What we didn't bargain on was the fact that we actually had members of the affected community who were medical practitioners who also backed us up in terms of the experiences that they had in private practice before the scientific studies when I recently published to demonstrate that non-native electromagnetic frequency radiation is categorized as a carcinogen type 1. So, that was very, very helpful. And these are genuinely concerned members of our own community. And I believe that it's not only limited to us. The second question that you had was in terms of the public officials. Absolutely, they're not always qualified to understand the highly technical nature of the equipment that gets adhered to these towers or to buildings sometimes. It's not necessarily just confined to towers. I don't just want to demonize the tower companies, because these frequency emitting mechanisms often also get applied to buildings, church towers, to all sorts of structures, which is the highest point in the area. That's the most favorable. And I think that the government's obligation to provide that kind of expertise is something that should, strictly speaking, form part of our social contract with government. Because if you look at the constitutional imperative that we're entitled to a safe environment, we have two kinds of relationships that our constitution considers. The one is what we call the horizontal relationship, which basically means that how we as citizens engage with one another should be consistent with the principles of our constitution when we engage with each other on a horizontal level, me and you. Then we have the relationship, which is the vertical relationship, vertical constitutional relationship, which is the relationship that we have with our local government, which is the first tier, our provincial government, which is the second tier, and then our national government, which is the final and the highest tier. And that's all vertical. And because it's enshrined in our constitution, our members of society have the legitimate expectation that our government will do something to protect us. It should. It should not at least permit such situations to arise where we are exposed to category 1 carcinogens, for example, when it can be reasonably prevented. So, to define those parameters and to define the role of government and to define the responsibilities of government, I believe will be our next challenge. And that's the new frontier, because it's uncharted at the moment. We're going to have to, like our draftsman of our constitution did way back when, we're going to have to borrow a bit from international jurisprudence. We're going to have to look at what's going on all around the world, to establish what the best practices are, and how best to ensure that our society is protected from any harmful, unintended or otherwise effects of the advancement of technology in our society. Government will have to play a key role, unfortunately, because it's unavoidable. Civil society can do so much with the legislation that we have at hand at the moment. But there are great voids in our protection as consumers and residents and citizens of the country, and the great strides that are being made in the advancement of this kind of technology. It affects us, according to scientific studies, adversely, and that means that morally alone, our government has a duty to do something about it, and the responsibility to protect us.
All right, let's go to the last question, because you've been very, very, very helpful in all this, and I know you've been having a long day. So, let's try a hypothesis scenario here, sort of discussing what on the aspect with the morality or about reasonable versus unreasonable accommodation. So, like the whole Star Trek thing of, does the needs of the few or the one outweigh the needs of the many? So if you take the example of, let's say we have a school, a classroom, and they're wanting to implement, very heavy-duty public Wi-Fi and put everyone on tablets. And from the science, we know that the tablets or the radiation of the blue light and the wireless does actually not make the kids smarter. It makes them, in a way, dumber. It restricts their lateral ability to think and has these other adverse effects. But let's say we have the thing of, government has been educated the mandate that it is the better alternative because it's cheaper, because you don't have to use paper textbooks, and there's other many advantages, and it can steamroll certain advancements. So it in a way on marketing it definitely betters the many. However, that you might have, say, one child or few children within the classroom that is being more adversely affected by the different types of radiation, where they could have headaches, or they're becoming more ill, or they're having trouble with keeping up intellectually with other children because of the interferences in their brain metabolism. So, how would one argue or approach the thing versus, fair or unfair discrimination, or reasonable, unreasonable accommodation? Because yes, it can be argued blue blocking filters can be put on the tablets, or, they could be LAN cabled, all these different aspects. But yes, it's about the thing is, if there's one child by himself, because we also know social accounting, social currency or stigmatism, there might be many that are complaining about it, like we have with rape or crime against women or children. But we have to rely with the systemic abuse of rights, that we have to then trust the one that's willing to speak up, because society can prejudice against them. So, how do we weigh up, or how do we handle such a scenario? If, let's say, a parent came to you with such a complaint or issue, and, what would be your recommendations of how to negotiate, or how to approach, if it would be a magistrate's court or equality court or high court, what would sort of be the hypothesis or the scenario of the situation?
Well, it's a very complex question that you pose, because if we go back to the genesis of where some of our biggest problems in society arise in the rural areas, where the very, very poor people reside, and they don't have equal access to education, technology, health, all of those issues. And if we have a technology that is able to bring that kind of education to the classroom in a way that's efficient, and that's technologically at the forefront of innovation, it almost ticks all of your aspirational boxes to bring a better life to those people. But the inadvertent or unintended consequence of doing this, as you rightly point out, would be that in certain instances, you could have an individual or a group of individuals who have a violent or a normal adverse reaction to this technology being brought aboard. Simply because it's I don't want to call it weaponized, but it's enabled. It's got electromagnetic frequency, and it's something that they might not be accustomed to, especially people living out in the rural areas. They might be more dramatically susceptible to be affected by technology, and especially by suddenly increasing the dosage of and exposure of that kind of technology, which is really foreign to them as a people. So I think I would break it down into a few phases. I think the first phase would be obviously your idealistic phase, where if you could bring technology to the rural areas, where your people who would otherwise not have access to it are given access to it. I think that's ideologically fantastic. I think that's in keeping with the advancement of basic human rights, and I think connectivity is also becoming more and more to become almost kind of right that we're trying to rely on. If I have to listen to the advertisements that we hear on the radio these days, they basically tell us that being connected is becoming a basic human right, and it's difficult to imagine suburban people without Wi-Fi these days. Whereas it's a daily reality for people in rural areas. So that's the first phase of it, and that's the introduction of this new technology to rural areas, which is usually met by great clamor, excitement, optimism, and everything that goes with that. The second phase is when the reality sets in for a few individuals, for the minority of the individuals who are adversely affected, initially strongest by this kind of technology. That how to address that. In the wake of the tide of optimism, of the tide of advancement and change that it introduces into that society. And I think the best way to deal with that is to get your public health experts up to a standard where they can be deployed to identify these instances. You do have modules and equipment and adaptive modes. You have adaptive accessories. That can cater for people with these kind of sensitivities. If they have to be exposed to this kind of radiation because they have no alternative, I think that is the biggest challenge that we're going to be faced with as a society. Because if you look at a child who's out in a rural area, who's in a classroom of 25 pupils, everybody has waited decades for technology to now arrives, but this one or two children have adverse effects of the radiation frequency. How do we accommodate those students and still give them the right to that equal level of education, but also make sure that their immediate concerns are taken care of. That's the second phase. The third phase is where government willingly participates in this program of bringing technology to its citizens, and when it does so, it should be guided by empirical data and scientifically backed research that cautions that this could be dangerous. If it is found to be dangerous overseas and abroad, and we use the same technology, it could be dangerous for our own people as well. And if government does nothing about that, then the reasonable apprehension exists that they themselves could inadvertently be part and parcel of a new problem that would arise in the next dawn of the technological breakout. And that is that they could unwittingly become a participant to a massive class action downstream, where now in 2018 we've put the scientists have put a peg in the ground to say this is dangerous. It's a category 1 carcinogen. Careful how you go about using this technology, because it could be life-threatening if it's not correctly used. And I believe that any responsible government should be guided by that as a starting point. And knowing that we have to get even our rural and our poorest of poor people educated by all means possible, and especially if we can employ technology, that they have an added responsibility to the public as our custodians to ensure that whatever it is that they employ should be done in a responsible and safe manner, which is in any event a constitutional imperative imposed not only upon us as citizens, but also on them as a government.
Michael, thank you so much for donating your time this evening. I know I've taken you away from your family, and we would like to thank your family also for generously abiding by giving your time to help us. And so, I mean, in a nutshell, basically, the idea is for people to be as civil as possible and try to have an open dialogue conversation. They said, there's those few individuals that do complain. I've seen and witnessed people experience being told if they're not happy, they must move to the Karoo. At a recent church, the minister came out and he told the members of the public, if you don't like the cell phone tower, move to the Karoo, go away from it. And others were told, if you're having problems, go to the local Sangoma. And again, there's ignorance or not understanding, and through these conversations and dialogues, this is able to go forward. But if people are, experiencing objections or harassment or abuse, then they should find like I said, their local attorney to help mediate on their behalf, to help burden them from the unnecessary emotional stress, because that only is going to hamper the situation even further. And if they struggle with finding a local expert, then definitely they must, contact your firm, expertlaw.co.za, and get some information or guidance, or if they're in Gauteng, contact you directly, and have an initial consultation and see what's the best way to going forward. Because everything doesn't have to go to the courts or constitution court, this whole big over drama and aggression, because it's expensive, it takes years, it's troubling. Where rather you can have a conversation on the table. And that's where you said the Minister of Law part comes in, because if you request a conversation on the table and you want to do the whole information assessing process, but your opposing party or installers or even your government officials are being resistant to the process, either because their own fear or a conflict of interest, then yes, they have to go back to parties like yourself to help strengthen, re-advocate this administrative process. And the important ethos of it is the Batupela principle that enshrines at putting people first and society first. But thank you so much. And if you have any final comments or advice, please share with it for us. And I'm sure this is going to help many, many people across South Africa and internationally.
Thank you. Well, I think, I'm also a qualified mediator, and that has enabled me to use dialogue and engagement extensively to diffuse these situations, all of them so far, before having to resort to the courts. Even though I'm a lawyer, and that's where we feel most at home, we haven't had to resort to the courts yet to resolve any of these issues. They've become resolved basically due to pervasive and thorough and well-researched engagement with members of the affected societies, and obviously also with those opposing and wanting the technological advances. So my message really to the members out there of the public is, be very vigilant, do your homework very thoroughly, make sure that you are knowledgeable, because knowledge really is the key to your freedom and to the choices that you're going to make. Wherever you doubt, reach out, get some legal guidance, and then if you form a collective, you might pool enough resources for one proper, decent, immersive consultation with a qualified lawyer who can just set you on the right course. You'll know very quickly it's not rocket science. It's something that affects us as human beings. It's something that you are procedurally entitled to. And it's something that is going to be a relevant issue for humanity for a very long time coming. And I think the quicker that we as members of society get our heads around it, understand our rights, and understand the responsibilities of those who want to integrate new technology into the fiber of society, the better we can cope with it, because that will also balance, their responsibilities and the way that they conduct themselves towards members of society. It will lead to a lot more responsible decision making, I believe, and I hope, from those at the helm of the technological advancements. And then obviously also consider your alternative technologies that are making great strides at the moment, and which aren't as harmful as the ones that have now recently been discovered to be, which don't necessarily emit the carcinogenic doses of frequencies, but still achieve the same aims. So we do have alternatives, which is the bright light. But I think the final parting word would be to be vigilant as a member of society. Be aware of what's going on around you, and don't be afraid to reach out and form a collective and see how many other people it affects, and that's how you protect your rights the strongest. And thank you for your opportunity also, and for the members of the public taking this time to listen to us. This is a great conversation. I hope we can get it going all across the globe. It's affecting all of us in different ways, and it's most certainly going to affect the future generations in many different ways.
Thank you, and we hope to hear more from you in the future on updated developments and advisements in the future.
Most definitely. I'll definitely let you know the moment that something interesting and exciting happens on the legal front as it intersects with this specific issue.